Hello everyone, this is Madhuri, Associate Professor, Department of Law, Padmavati University. Winding up of a company. This is the last chapter in the company's law. Here in this we can see introduction, meaning, types, procedure, liquidators, how are they going to work and what is the role of an auditor and how the powers and functions of an auditor will work. Winding up of a particular company to bring an end of the life of a company. A distinguishing feature of a particular company is a perpetual succession, which means that longevity of a particular company does not depend upon its members or their financial status. Even if all the members of the company go bankrupt or all of them die, the company will not dissolve on its own unless it has been made to dissolve on the grounds which are laid down on the Act. Winding up, we can just say, is nothing but the Companies Act, the legal processes of a particular closing and dissolving of the company's business entity. It may be initiated voluntarily by the company's shareholders or the directors or mandated by the external factors such as financial insolvencies. The process involves realizing the company's assets, setting its debts, and distributing all kind of remaining funds or assets to creditors and the shareholders in accordance with the legal hierarchy of the particular payment priorities. Winding up marks formal terminations of the particular companies or the legal existence, and the types we can see voluntary winding up by the court, and members voluntary winding up, and at the same time this winding up speaks on section 425 of Companies Act 2013. Winding up by the court or order of the court is essential when they want to give any kind of a conclusion for the business. Procedure, if you want to see, section 271 gives you a picture of 2013, that is a sick company. Special provisions act against the state or the fraudulent conduct of the business, failure to the financial statements with the register, and it is just and equitable to the winding up. Procedure, if you want to see here, compulsory winding up of the particular company by the tribunal. Appointment of the liquidator is must under Companies Act section 275 to examine the company debts and credits in order to verify the company's eligibility to forced why it is going to be coming to an end. Following appointment of a liquidators, section 281 gives you a picture of a report from the tribunal. The tribunal issues orders to the liquidators in dissolving the companies under section 282 of a particular company, and according to which a company's property undergone shift in the custody order to satisfy the creditors and contributors first. Finally, the court issues the order for the dissolution of a particular company under section 302 of Act, and after that carefully reviewing the audits and reports, providing the liquidator to the court's interest of the resolving obligations owed to the creditors and other contributors. Voluntary winding up of the particular company comes under section 304 Companies Act 2013, specifically two statutory conditions in which the company may be voluntary winding up. And here the company general meeting approves a resolution requiring a companies of the winding up voluntarily, consequences and then expiration of the companies and the duration, if any, as per the articles occurrence, and at the same time the company will be dissolved. The board of directors approved a special resolution requesting them for the winding up of a particular company in a voluntary way. So here the procedure for this is it begins with the board meeting when the directors approve a resolution confirming the company's financial status on the intent to winding up. Subsequently, a general meeting is held, and at the same time ordinary or the extraordinary resolution passed a majority winding up process. A creditor meeting follows with the 2/3 of the creditors' agreements in required process with the particular voluntary winding up. After the liquidator has been appointed, the registrar is notified within 10 days. Certified copies of the resolutions and submitted to the registrar within 30 days. The company affairs are then systematically wound up, including the preparation and audit of the liquidator's accounts, a resolution enacted disposition of a particular company records. Within 2 weeks of the general meeting, an application for the resolution made on the tribunal is absolutely needed. The tribunal associations also will become within 60 days, and the liquidator submits the particular register, who subsequently issue a notice to the office gazetted. This process ensures a legal complaint and fair voluntary winding up of the particular company. A liquidator is a person who is an entity appointed overseas of the process winding up or a particular liquidators, and the particular company will be taking according to that, convert them, and at the same time settle the company debts, and at the same time disputes the particular remaining of a particular business. Liquidation can offer and the particular reasons such as bankruptcy, insolvency, and the particular voluntary winding up of the particular companies. The liquidator duty is to ensure the liquidation processes and at the same time fair orderly manner also should be taken according to the laws and regulations. Powers and functions of the particular official liquidator will be coming according to that company's assets, protection of assets, realization of assets, settlement of claims, and reporting also should be taken according to that. So investigating inspectors and at the same time a particular company holders also will be taken, the court will be taken, and at the same time the proportion of an uncondoled and at the same time misconduct or financial things also should be taken according to that. Investigating inspectors preparing the particular ways will be taken according to that. Such findings and recommendations for further legal actions or the remedial measures also should be taken. So powers and functions of an investigating inspectors in the winding up, we can say about that: investigation, reporting, and recommendations. It is based on the findings investigating inspectors and at the same time recommending a particular assets of the particular against the company's officers, directors, and other find of a misconduct. Auditor also will be taken according to that. These particular auditor qualified and independent professional firms and at the same time responsible for examining and verifying the financial records and the statement of the particular company. Completeness in the financial information as well as the particular companies also should be standing, and auditors provides an opinion that particular company financial health and integrity on the particular audit reports also should be taken according to that, and auditor plays very important key role in the financial transparency and accountability. And here the powers of him is a verification of an accounts, reports to the courts, assistance to an official liquidator are the main jobs for a auditor. And finally, I can say winding up of a particular company forms a formal procedure for ending of an existence, whether due to insolvency, bankruptcy, or any kind of voluntary closure. The process involves the particular appointment of an official liquidator to manage the sale of a particular company, assets, settlement, and the debts, and equitable particular ways of business, distribution or the remaining funds among the creditors and the shareholders in line with the legal priorities. Authorities or the particular auditors and investigating inspectors may be involved to ensure financial transparency and uncovered irregularities. Winding up is a highly regulated process, and at the same time it has been designed protect the interest of all kind of stakeholders. Once the complete cease to exist legal marketing end of the corporate journey, whether it financial closure, legal resolutions, and at the same time achievements of its objects. Thank you all.